I want to welcome everybody. And again, who are we? Let's identify ourselves. The Collin County Republican Men's Club. This is our 52nd year. We're the traditional Republican Men's Club. And what happens here is we're many women join together, read with me, just Lord.
Join together,
Learn together, and work together for the Collin County Republican. You like that policy? Okay. Very good, Judge. All right. With that in mind, let's have a. Now, Jay Satt's not here?
Yes, he is.
Where's Jay Satt? Oh, there he is. Okay, very good.
I get my candidates here.
She is. Yes, she will indeed. Okay. Let's have the pledges. Jay, will you come forward, sir? And Jay Satt, and do the the Pledge of Allegiance. And then, where's Dr. Chappell? Come on up and lead us in the text. Jay, are you ready?
Yeah, ready?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dr. Chappell, on up to the front.
Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Thank you, gentlemen. Please remain standing for a moment, and let's have our invocation. Okay, our Vice Chairman, John Myers.
Join with me. Lord, thank you for all that you do for all of us here, for our country, for our county. Lord, we pray that you would watch over us, protect our families, Lord, be with our elected officials, give them wisdom, give them understanding, Lord. We pray and thank you for all the things that you've done for us individually and as a nation and as a county. In your name, amen.
Amen.
Thank you, sir. Please have a seat. Now we have a double feature tonight. I have a young man from the University of Dallas that's going to provide our educational segment on the 14th Amendment. Now, who knows about the 14th Amendment? Everybody should. So we'll let him to define its impact on us. We have a little special event that's coming in next. The Mayor of McKinney, George Fuller. And George wants to address the House Bill 2 issue. And so he's going to be the second part of our program this evening. Now, I want to give him some added recognition. Somebody who takes forever to learn how to pronounce his name, so stand up, David. Okay. I want y'all always get to remember David Niederkorn. Okay. He's not only famous, okay, he's got a reputation. He takes on running for any candidate, okay, and ran for Senate. David is a professor of political science, all right, and he's helped us. And the reason I'm giving you recognition is he's taken on the burden of assistant program chairman. So this evening we have So David, with that in mind, why don't you introduce us to our...
All right. Love to. Definitely my honor, because our guest tonight is very special to me, so I want to be special to you as well. When I first went to the University of Dallas, I was looking over the schedule, of course, to pick up my classes, and I saw constitutional law. That sounds interesting. Read the course description. Yeah, I'm in on that for sure. Got a B+ in the course, though. Now, I know that doesn't sound detrimental, but I just finished 2 graduate programs with Code 4.0. And I'm a nerd, so the B+ was a problem. Now, here's my problem. Now, if you ask a professor, he'll probably tell you I had more problems than just the one. But the challenge in taking a course with Dr. Upham is that in addition to a PhD from the University of Dallas, he also has a Juris Doctorate from the University of Texas. So he has this mind that is half political philosopher and half lawyer. So imagine what goes on up there, right? Trying to make this guy happy with a paper, you know, no matter what you do, it's not in logical order and it's just wrong and it's very difficult. In spite of all that, though, next semester I took a course called Civil Rights, which is kind of like Common Law 2. The centerpiece of that course is the 14th Amendment, because if you understand the 14th Amendment, you understand so much about what's going on in the expansion of civil rights, how the progressives in particular have used it to, in many ways, redefine our Constitution. So that's what we're going to talk about tonight. So please welcome our guest, Dr. David Upham.
Did he deserve the B?
Yes, I was being especially generous, right? It was.
Remember, you're recorded on that.
I'm delighted to be here. Thank you all very much for this. Thank you, David and Mr. Dodson, and thank you all very much for the opportunity to talk about something that I find fascinating, even though in some of the details, as you'll see, I find it somewhat disheartening and depressing at the same time. And that is the history of our Constitution, and in particular tonight, the history of our Constitution in relation to what we generally could call male and female, and what's happened most recently. Just about a month ago, a Texas federal judge, Judge Gray Miller, writing for the U.S. Court for the Southern District of Texas down in Houston, held that our Constitution, fairly construed, prohibited the United States from subjecting young males, but not young females, to compulsory registration for the military draft. Now, according to Judge Miller, the central question involved, quote, the tension between the constitutionally enshrined power of Congress to raise army and the constitutional mandate that no person be denied the equal protection of the laws. Now, that's a claim that the Constitution says two things. Congress shall have power to raise armies, and that no person shall be denied equal protection of the law. I wanted for this evening, I know all of you have a copy of, you all have a copy of the Constitution right there? Is the Declaration of Independence included in that?
Yes, it is.
Okay. I have also here, for if anyone wants to, I have excerpts, a one-page excerpt of the things I'm going to be quoting from. If you wouldn't mind just passing these around. Looking at the relevant passages. So the claim was, we have two things and we have to resolve them. That's what's at stake here. Congress has power to make an army. And secondly, no person should be denied equal protection of the law. Anyone familiar? Should I use the microphone? Or is this fine?
Up to you.
Okay. You
Use it.
If it works.
Oh.
Ready to speak, Sid.
Okay. I don't know if this is actually going to be more helpful. We'll see.
It's not.
I think you were good before.
Maybe just turn it off. Sorry.
Be your own microphone.
Okay. Now, anyone familiar with the text of the Constitution and the history of our Constitution might be baffled by the claim that the all-male military draft poses a tension between Congress's power to raise army and a, quote, constitutional mandate that no person shall be denied equal protection of the laws. The text of the Constitution does indeed say Congress shall have power to raise and support armies and to provide and maintain a navy. That is in the actual Constitution. But the Constitution does not say no person should be denied equal protection of the laws. It says something more specific. It says that no state, that is to say, it does not apply to the federal government, no state shall deny to any person within its jurisdiction equal protection of the laws. The 14th Amendment's Equal Protection Clause, therefore, in two respects, is not coextensive with the principle the court said is aimed there, namely that it doesn't apply to the federal government. It says no state. Congress is not bound by the Equal Protection Clause. And secondly, it does not guarantee to all persons equal protection. It guarantees to a certain subset of the human race equal protection, the persons who happen to be inside the state's boundaries. The manifest purpose of the Equal Protection Clause, by its text, by its history, was to say simply this, something rather profound, something very important, something very easy to apprehend. If somebody happened, a human being, made in the image and likeness of God, happens to be inside a state's boundaries, they can't declare open season on their lives, on their bodies, on their stuff. Doesn't matter how you get here, you get in here by a hot air balloon accidental, a tornado picks up your house from Mongolia and it drops into Texas. You have a right to be protected against homicide, kidnapping, theft, simply because you're a human being happens to be inside a state, because the state's job is to protect fundamental natural rights that belong to all human beings as such. It is not a guarantee, therefore, of equality in every respect. It's a guarantee of equality in a very fundamental, raw sense, the absence of which can be terribly painful. No, the government won't protect your life. The state will ignore your kidnapping or the destruction of your property. Now, moreover, even if the 14th Amendment did say every person should have equal protection of the laws, Congress must respect that right. It would still be rather strange to say that that should prohibit the all-male military draft, because we've had all-male militaries, and when we've had compulsory military service, it's always been discriminatory on the basis of age and sex. And it would be rather strange to say that the Constitution, established by the generations that won wars on the basis of compulsory only male military draft, meant in any way to say that it's now unconstitutional. How then did we get here? How did we get to the point where a federal district judge could say something that prior to 1970 or so, there was no record of anyone even asserting or claiming that our Constitution, fairly interpreted, means that Congress can't discriminate on the basis of sex as well as age in identifying that subset of citizens who will be subject to coercive military draft. I want to divide up this talk into 7 steps, how we got here. And the first step is the founding, the American founding. On July 4, 1776, the United States was born. The people of the United States, acting through their colonial, then state legislations, and the delegates sent to Congress, declared the independence of the United States. The independence, in turn, was as a practical matter won by force of arms. And the military that won that war was a military composed in large measure of members of militia, and the militia membership was compulsory under local and state law. The militia membership, as defined, was always discriminatory on the basis of age and sex. Certain people were not going to be drafted if they were too old or they were too unmale. Or too young. The Declaration of Independence, in turn, said something interesting about military matters of relevance to this. In charging the king with having a tyrannical government, our founders listed several grievances against the king. And one of them I excerpted in the handout. Does anyone have an extra copy? I gave away all my copies. Thank you very much. Thank you. It said something, probably overbroad, overgeneralization about the American Indian tribes. It complained that the king had declared that the Indian tribes ought to wage war against the United States, trying to declare their independence. And one of the complaints was not warfare, but the mode of warfare. He has brung onto our inhabitants of our frontiers the merciless Indian savages, who fight war badly. Why? Because they don't discriminate on the basis of age or sex or condition. That it's a sign of savagery that you wage war without wondering whether the person is a combatant, a child, an old person, or a woman. We don't fight wars that way. And the king should know better. And that's one of the reasons why his government is proven to be tyrannical, and we have a duty to declare independence. Now, after independence was won, various state and federal constitutions were adopted. The Articles of Confederation came first. That proved by unanimous consent to be not working, and then a new constitution was adopted. And upon its adoption, the ratifying conventions largely called for amendments. Something like a Bill of Rights ought to be added to the Constitution. And the first Congress in 1789 got together and said, among its first order of business was drafting a new set of amendments to the Constitution to keep the promise made by those at the convention, said, please adopt the Constitution. We promise we'll give you a Bill of Rights later. And one provision of that Bill of Rights is found in the Fifth Amendment, which says that no person shall be deprived of life, liberty, or property without due process of law. That's on the handout there, Amendment 5. Where's that from? What does that mean? Where is that from? It's actually ancient. It goes back at least to 1354 and actually well into even the pre-Magna Carta era of English law. Magna Carta said that no free person should be deprived of life, liberty, or property except by the law of the land or the judgment of his peers. 150 years later, in 1354, the English Parliament adopted a statute that said no person, no human being, of whatever condition or estate he may be, even if he's a serf, a kind of slave, should be deprived of life, liberty, or property without due process of law. So that phrase, due process of law, goes back at least to the 14th century. And the founders in the Fifth Amendment, and in many of the state constitutions, simply copied and pasted from medieval texts that had been deeply present in Anglo-American law for a very long time. Suffice it to say that during all of that time, there's no record whatsoever of any substantial challenge being made that sex discrimination in military matters violated any of those provisions. That men or women were being deprived of liberty or life without due process of law by making that distinction. So we're dealing with, the due process of law has centuries of precedent to support its sort of general meaning and its relationship to this notion that male and female is a legitimate or not illegitimate distinction. That's step one, the founding. So we got a war won by statesmanship, yes, but also by force of arms, by the American people, operating in part through compulsory military service imposed only on certain citizens based upon their age and their sex. We have a constitution that's adopted, which includes soon thereafter a Bill of Rights, which says no person should be deprived of life, liberty, or property without due process of law. That was intended originally to apply only to the federal government, because it was only the federal government that they wanted to limit through that Bill of Rights initially. That's step one. Step two, Civil War and Reconstruction. Despite the founders' principles of universal liberty and equality and the duty of government to secure to all human beings the rights of liberty and property within the jurisdiction, the founders did not carry those provisions all the way to their obvious conclusions in all of the states. Slavery remained. Slavery remained and became even more powerful and was, by all accounts, at least a significant cause of a disastrous, horrific civil war. In winning that war, the Union relied upon a compulsory federal military draft for the first time. In the founding era, it was state-based compulsory militia. But then you had a military draft, also, of course, discriminated on the basis of age and sex. It was highly controversial, but no doubt played some role in the victory of the Union. That victory, in turn, defeated not only secession, but abolished slavery. And it was primarily military arms that did that, as Lincoln said in his second inaugural. The progress of our arms is upon which all else chiefly depends. You've got to win wars. You don't free slaves unless you win wars. You don't restore unions unless you win wars. And they relied upon this obviously discriminatory practice of saying young males are different, and we're going to treat them differently as the only ones who are going to be subject to this coercive draft. Young, but not too young. Young adult, more or less. Are 18-year-olds adults? Well, in a way, right? As I get older, it changes. You know, my definition of young and adults.
As you get older, it changes.
Yes, I know. I was very delighted to be called a young man. I'm almost 48. I'm past the median age. I am actually over the hill by all accounts. But I understand. You know, depending on the age. I stopped. After the Civil War, the defeat of secession and the defeat of slavery, the United States, through Congress and the state legislatures, made a decision to amend the Constitution in several important ways. Overall, the chief purpose of these amendments, the Reconstruction Amendments, was to say the 1/8 of the population, marked by geographical concentration and by their race, are going to be parts of our country as equal citizens. A multiracial republic was going to be established and is going to be a fundamental principle of the American Constitution. And that multiracial republic is established in the 14th and the 15th Amendments. The 13th abolished slavery, made, free men, but not necessarily citizens of So the 14th Amendment, Section 1, has a mandate, and we can look at that. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state where they reside. No race there's no race qualification, there's no hereditary qualification whatsoever. No state shall make or enforce any law which shall abridge the privileges of citizens of the United States, nor shall any other state deprive any person, not just citizen, of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the law. It's that equal protection clause. Now, I'm going to go in reverse order discussing this, because what these mean, because although they appear this way in the sequence of the text, both in the history of the drafting and also in a certain logical order, the last actually becomes first. First is equal protection. Government is there to secure natural rights that belong to human beings. Good government does that. Bad government can't do it or won't do it. Such as, I get to live. How about that? I get to walk around with my freedom, not in chains, not in slavery. I've got my stuff in my pocket, my property. You can't just beat me up and take it. And government is there to put the smack down and say no. And also the government must not, in turn, now we get to the due process clause, use its massive apparatus to kill you, enslave you, imprison you, take your stuff, except for very good cause, like crime. And how do we know whether the government has good cause? Well, we have an old, as I said, very ancient set of rules that says due process of law. You've got to follow the rules. Some of them are actually, well, again, medieval rules of things like prosecution has to prove the case. Got to get a jury trial. The Supreme Court's going to decide today whether this means unanimous jury trial. I think it probably does, by the way. Lots of different hoops to go through. Both of these two clauses mean the same thing. I'm a human being created by God with inalienable, fundamental human rights simply by showing up. Life, liberty, pursuit of happiness, which includes the right to keep my stuff. And the government is supposed to protect me, affirmative duty to act, get up, show up. And secondly, don't kill me, don't take my stuff, don't throw me in prison. Sometimes the government has to do that, right? We've got to, well then we'll have this rule, due process we'll have to go through before they do that. Okay. Those are fundamental human rights, and they're asserted there because in many parts of the South, and I don't want to speak too broadly, Texas was not nearly as bad as a place like Mississippi in this respect, but in many parts of the South, there's kind of open season on free blacks, open season on white unionists, Republicans, and the federal government just said, we don't trust the states to do this, so we're going to make a constitutional rule that says you've got to protect people and you've got to not take away without due process. And not included here, Section 5 power gives Congress the power to step in when the states fail. Principally things like lynch law were the problem. Never actually adequately solved by federal power. That's another story. But this clause before it said, the two clauses before that deal with citizenship and the privileges. We'll get aside the who is a citizen, but the privileges or immunities clause. And that's where the law wasn't designed to simply protect the right of anyone, no matter who they are, where they're from, just happens to be on a, stumbles into the country drunk off a hot air balloon that flew in from wherever. That person doesn't necessarily have a right to vote, obviously. They may not necessarily have a right to continue to live in, walk around, participate in our markets of real estate, personal property, employment markets. Those things are not human rights that everyone can do everywhere they go in the world. I don't have a right to get a job in Mongolia. I do have a right to not get killed in Mongolia. This is what this was about, because a lot of the southern states were basically saying, but through black laws, especially Mississippi's was very harsh, just said, blacks can't do this job, can't do that job, can't live in this neighborhood, they're going to be subject to these curfews, etc. These extensive codes that don't say, we're going to kill you, or we're going to enslave you, but do say, you really aren't a citizen, you can't participate in the economy here. You can't participate in traveling around. You're going to be subject to a kind of like a weird sort of special visa, what we would today call kind of like a special visa to live among us. That's not, we're going to have, the 14th Amendment says no, we're going to have equal citizenship. And primarily to prohibit racial discrimination or other forms of hereditary discrimination. All Americans born in the United States are Americans. They're entitled to equality before the law regardless of race. That's what this amendment, that section is primarily about. 15th Amendment goes further and says the right to participate in political authority directly, the right to vote. Not just the right to go to the market, not just the right to get jobs, to speak, to travel, but also the right to participate in the suffrage, the 15th Amendment. You'll notice that binds the United States as well as the states. Something of significance. When the people at that time wanted to say the United States, they knew how to say it. When they only wanted to bind the states, they knew how to say that too. Okay, important point. So that's step 2, which is Reconstruction. Establishment of a multiracial republic. It was established by force of arms by an including a military consisting in part of an all-male military draft. What did these amendments say at all about male and female? First, no one in his right mind at this time denied that persons were all human beings, including male and female. No one said, my mother's not a human being. There was no debate about this. You often hear these kind of outlandish statements. Well, you know, back then, they didn't even think women had souls. There's stuff like this, like, who says this about their own? Just, one of these, when you make an assertion about the human being, you assert in olden times. The second thing is no one denied that women were citizens. In fact, many of the most prominent cases involving privileges and immunities and citizenship involved women litigants. No one said, it was not even an issue. Well, you're a woman, so, I mean, why are you here? There are real discriminations. Voting rights, yes. But personhood and citizenship. There are other discriminations that are available at the time, and those are somewhat challenged. Laws, for instance, that said, Illinois said that for a while that they would not allow women to be in the lawyers. Bradwell versus Illinois comes in the Supreme Court. A divided Supreme Court upholds the law for different reasons, although the Chief Justice dissented. And it was clear he dissented because he thought the 14th Amendment's equality meant that women had an equal right to the professions. But what about laws that are not designed to reserve professional life to men, but are designed in a kind of protective way, like the draft? There's no record of anyone challenging this at all, saying, hey, the equality of the 14th Amendment can't be satisfied. There's also new laws being developed that say maximum hours legislation factors. So you get laws that say no one under 21 and no woman shall be employed more than 10 hours standing in one of these New England mills. That law was challenged, but not on the basis of sex discrimination before the Massachusetts Supreme Court, 1876, so about that same generation. And the Massachusetts Supreme Court effectively just said, you can't be serious. Of course we can pass these types of laws. But again, let me emphasize, no one said, hey, sex discrimination is the problem. What they said was, hey, shouldn't she have a right to work how much as she wants? Okay. But no one said it's unjust to have a protective law that discriminated not only basis 21 and under, but also male and female. That's step 2. Now step 3 is what happens to the 14th Amendment soon after it's adopted. This is a complicated judicial matter. But what happened is that equality under the law, which is the privileges of citizenship, I have a right to equal citizenship, that got moved to the Equal Protection Clause. How did it get moved to the Equal Protection Clause? Well, in the slaughterhouse cases, I don't want to get too deep into this. Slaughterhouse cases, the Supreme Court misinterpreted the Privileges or Immunities Clause so badly as to mean that it no longer meant by itself what it was intended to mean, meaning equal civil rights, regardless of race. But everybody knew that the 14th Amendment was about equal civil rights, regardless of race. So what the court did in a subsequent cases, they said, you know what we're going to do? We see that word equal in the Equal Protection Clause. That looks promising. So they turned equal protection of the laws into equality. Pay no attention to the noun protection. Pay no attention. We just want it to be an equality clause. So if any of you, are anyone here lawyers? Okay. If you went to law school, you're in equal protection. The word protection doesn't exist anymore. It's the equal stuff clause. It became the equality clause. And that was, there's a lot of complicated, interesting, and frankly, highly debated among scholars as to what was going on in this period. Why they killed privileges or immunities. But what they all wanted to do was keep the basic raw point somewhere. Whites and blacks have to be equal before the law. If the Privileges or Immunities Clause doesn't do it, what can we do? Well, we'll turn to that Equal Protection Clause. And in one famous turn of phrase, Iqbal versus Hopkins, the Supreme Court said, equal protection of the laws is a pledge of protection by equal laws, which sounds persuasive, but it actually doesn't mean what it says. In fact, the equal protection of the laws actually requires highly unequal laws. For me to be equally protected, I hope that there is a very discriminatory process for identifying who's going to be the judge in my case. I don't want any old person to be the judge. I'd like someone to know something about the law.
That's discrimination when you say any old person.
That's right. Any senior citizen person.
How about any citizen?
Any person or citizen. Yeah, I'm not interested in just, yes, actually, and in fact, for purposes of police protection, I'd like someone who's maybe even stronger than me. That would be good. I prefer physical strength, dexterity, ability with firearms that I don't possess. Those are specialized things. An effective protection of the laws requires a discriminatory mode of enforcing them. So no, but this was a textual game that the court had to play because it didn't know how to get back the Privileges or Immunities Clause. But it didn't want to totally erase the 14th Amendment. And that's very important. And even in the segregation cases, Plessy versus Ferguson, the Supreme Court did say, well, we all agree that absolute equality before the law is necessary. So equal protection becomes equality before the law. Now, step 4, women's equality in the late 19th and early 20th centuries. At the same time, the 14th and 15th Amendments are being adopted. Even before that, in the 1830s, you have lots of political reform movements, some of them successful on a state-by-state basis, of overturning rules like, hey, women can't be lawyers. So in Mrs. Bradwell's case, she was denied by the Supreme Court, but later on the Illinois Supreme Court reversed its own decision and said, oh, I guess fine. So this was all going on between the 1840s and the early 20th century. A lot of federal territories in the 1860s and 70s already had the women's suffrage. Sometimes here, 1920, women are given the vote. Women already had the vote in a lot of territories and states, growing number in the late 19th and then into the early 20th century. And then it snowballs. So the 20th Amendment says, no sex discrimination as to voting. At roughly the same time, you start getting increased objections to minimum wage and maximum hours laws for women. Here again, the primary objection wasn't not gender equality, but the right of women to decide how long they want to work. So these cases up and down, the courts will go back and forth on it. After, in 1920, the 19th Amendment, which I have stated here, is adopted, and the Supreme Court a few years later in Adkins versus Children's Hospital strikes down a federal minimum wage law in the District of Columbia for women. In part on the ground that it's just undue restriction on women's liberty of contract. That little brief era of the courts being suspicious of protective legislation is reversed in 1937, when what we today call progressives, who are heavily in favor of protective economic legislation, uphold and overturn Adkins in a series of cases, just saying, we're going to allow there to be minimum wage laws, including minimum wage laws only for women. Now this part of history is a little bit confusing to us because modern progressives like to rewrite the history of the world as if it's all one linear development leading to them. But actually if you wanted to ask when was the first time the court was saying women's right to work equally with men, it's like 1920s, but it's the people striking down minimum wage laws. And that means they're the mean ones by contemporary progressive standards. So in 1937, you have this case where the crabby conservatives on the court are insisting that women should be able to work at lower wages if they so choose. Freedom of the market. And you've got the progressives on the court saying, come on, we're having minimum wage laws for women. The same progressive court, the New Deal court, upholds, 1940s, upholds a state law that says, that limits the degree to which women can work in bars. And it's kind of laws that say women can work in a bar only if they're related to the owner. We'll have family saloons are fine, but we don't want single women or women unrelated working in these types of establishments. And the Supreme Court says that's not unconstitutional. This is as late as about 1950. Okay. Again, I would just go back to the original understanding of the 14th Amendment. These type of laws were not unconstitutional. The equality of women before the law did not prohibit the states from having some kind of protective attitude that discriminated on the basis of sex as well as age. But by the 20th century, this type of claim is being made more successfully. That's step 4. Step 5, the Warren Court and Brown versus Board of Education. In 1954, the Supreme Court, in my opinion, rightfully interpreted the 14th Amendment to prohibit racial segregation in public schools. The 14th Amendment binds the states. Keep that in mind. No state shall abridge the privileges or immunities of citizens of the United States. The court had a problem when it was deciding that case. The court was sitting in the District of Columbia, and the District of Columbia also had racially segregated schools. And the District of Columbia is not a state. Was the Supreme Court going to say the 14th Amendment, because it says states, prohibits racial segregation in schools? But the District of Columbia is not covered by that, and that's not unconstitutional. May I say, Robert Bork, among others, so I'm in good company, Robert Bork, among others, said that's what the court should have said, because that's what the Constitution said. Not that racial segregation is good, but the Constitution says no state, and that's the provision we're relying on. When you get to the District of Columbia, for good or for bad, it's not a state. And the Constitution says what it means what it says. But the court was very uncomfortable with this. They wanted to eradicate segregation. They also thought that it would just roll out badly. So they fudged it a bit. They kind of, well, they made something up. And they all but said so in the opinion. In the concluding paragraphs is Bowling versus Sharp is the name of the case. The same day as Brown versus Board of Education. In view of our decision that the Constitution prohibits the states from mandating racially segregated public schools, it would be unthinkable that the same Constitution would impose a lesser duty on the federal government. Not unthinkable. What if that's what the Constitution says? What if the states have some prohibitions but not the federal government? It doesn't mean that all of this makes sense. It may very well be that it doesn't make sense to have 2 senators per state. The founders did that because they wanted at least 26 in the Senate. They thought 13 would be too small. Now that we have 50 states, maybe we have too many senators. But the Constitution still says 2. So the court made an argument. What the court said effectively is, well, equal protection of the laws is included back in that due process of the Fifth Amendment. And there's so many just historical, textual, just absurdities about this. Retroactive incorporation. And if that's the case, the redundancy, because the 14th Amendment has a due process and an equal protection clause. If equal protection is in due process, why say both? But the court needed a way to say the federal government can't segregate public schools either. Does that make sense? So they said it. But that doesn't mean the last time they used it. It wasn't just a one-off, okay, we got it done. And they've used it in many other cases. Most recently, the Adirondack case in the 1990s involving affirmative action, where the conservatives struck down federal affirmative action on the basis of the due process clause of the 15th Amendment that incorporates somehow the equal protection of the 4th. It's an enduring principle that only the crabbiest, and I use that term actually very affectionately because I consider myself a crabby conservative, only the crabbiest conservatives just say, I'm sorry, it's wrong. It's not our law. We never made that decision. Maybe we should. We have a process to do that, called the amendment process, 2/3 of both houses. Moreover, I don't think it was terribly necessary because Congress soon was more than enthusiastic about abolishing segregation in D.C. Didn't need the Supreme Court to do that. The American people were in favor of desegregation, and they voted for it overwhelmingly in 1964 through Congress in the Civil Rights Act of 1964. So back to the states. That's step 5. Taking the equal stuff clause and putting it into the due process clause, where it never was before. You know, the due process clause arose in a society that was highly hierarchical, with lots of hereditary caste systems. In fact, so much were those caste systems are noted that the very principles of due process reflected them. They'd say things like jury of your peers. People that are born to your class should be on your jury. We don't want rich people deciding poor people's cases. We don't want freemen being tried by serfs. We don't want, all of this is part of due process of law, can be coextensive with a highly un-American, unequal society. Due process of law in a way is something just far more raw and fundamental. If you're going to have somebody's life, liberty, or property on the line, follow very old, predictable, slow procedures that are well known and established by law, and not just judges doing ad hoc procedure. I often bring up Miracle on 34th Street. You know, the judge who's kind of comical. It's like, this is highly irregular. That's a good judge. When people's life, liberty, or property, they don't need to have some sort of dynamic judge who makes up rules on the fly. More likely than not, the defendant is poor. The defendant can only afford an attorney. I often tell my students, this is a little bit of a side note, the poor defendants notoriously have poor attorneys. And poor attorneys don't know all the latest dances, if you will. They can do the hokey pokey and the electric slide. And if the criminal case follows orderly procedures, you're at a much better state. But if you're in a state where if you're in a situation where you're a poor defendant and you've got to rely upon this judge, and the whole trial is always new and changing, you're going to lose. And you're going to die. You're going to prison. So, again, a lot more can be said about this, but that's stage 5. Now, stage 6 is the Burger Court. Burger Court is Justice Warren Burger, 1969 to 1986. The Burger Court decides such cases as Roe versus Wade, which says that our Constitution, fairly construed, prohibits the states from providing any protection of the laws, yes, equal protection, to prenatal human beings. So this is not a court or an era that is devoted to textual fidelity and originalism, to say the least. Okay. This court begins to revive very strongly the old sex equality decisions, and starts to strike down a number of things, like Oklahoma's law that says drinking age 21 for males, 18 for females. Because they couldn't help but note that virtually all the drunk drivers of that age group were male. At that time, at least. I don't know if it's still the case today, but it was stark discrimination, stark reality, like the maturity level of 19-year-old boys and girls, pardon the expression, was at that time just like over the top. So they said, we're tired of drunk driving and we're going to target it. But the court struck that down as unconstitutional. And the court also even heard the case of the military draft. 3 justices, Justices Blackmun, Justice Brennan and Marshall, and also Justice White, the 2 of which were in the majority in Roe versus Wade, wanted to strike down the all-male military draft, but 6-3 decision. So lots of judges who were willing to strike down lots of sex discrimination and give and establish legalized abortion throughout the United States. The court was still just like, no, that's too far. It's 1981 case. That's step 6. So we have this 1970s sex equality becomes a big part of our Constitution via the Equal Protection Clause in the 14th Amendment, and federal government, the Due Process Clause, which incorporates the equal protection. That's stage 6. We're now in stage 7. During stage 6, this was the beginning of some of the things that have since become events very successful. Marriage. 1967 or 68 was the beginning of the first marriage litigation, Baker versus Nelson. By my research, it was the first time anyone anywhere in the history of the world said that marriage can't simply be male-female, it must be male-male or female-female. And they were doing so as part of this whole cultural, sexual, and gendered revolution of the late 60s and early 70s. So it was a dramatic time for change. And by the time it got to the Supreme Court, the same Supreme Court that got us Roe versus Wade, every judge had said no, no, no. And the Supreme Court said, decided the case by dismissing it for lack of a substantial federal question, which is another way of saying you can't be serious. This is not a serious question. So it's not that they didn't hear the case. They did. They said, we looked at your case, get lost. And for 20 years after that, these cases continued, however. And every judge in the United States, as far as I know, everyone in the world said no, no, no. But then in the 1990s, you start having some of the judges, and then you have the history with which we're familiar. 5-4 decision in the United States versus Windsor, the Supreme Court relying upon you can now do this in your sleep, the Due Process Clause of the Fifth Amendment says that the federal government may not define marriage as male-female. 2 years later, the Supreme Court said the 14th Amendment, the Due Process and Equal Protection Clause, mean you can't say, the states cannot say marriage is male-female and cannot define it as such. That's the age we're in now. And I would just suggest to you that if, in fact, the court, by force of the Fifth Amendment's Due Process Clause or the 14th Amendment, can say that the distinction between male and female in identifying what this thing called marriage is and how it will be is unconstitutional, they most certainly can say that an all-male military draft is similar, because marriage is actually an older, more fundamental institution than the military. And certainly more universal than a military draft, which is kind of an unusual kind of coercion that communities rely on to get people to fight wars. So that's where we're at. If you look, again, if you just kind of, you might say, this is what's going on. I'm still saying that every day. Anytime you just spend some time with the text of our founding principles, the text of the Constitution, their original understanding, you know this is not, what the court is doing, whatever it's doing, is not interpreting the text according to its plain terms or according to its original meaning. They're engaged in something else. They're not doing it according to the precedents that lasted all the way up until the 1970s. That no one, we have no record of any challenge. I can rant on, but those are our 7 steps. The founding, Reconstruction, the transfer of equal rights under law from the Privileges and Immunities Clause to the Equal Protection Clause, that's step 3. Step 4, women's equality with women's political equality, 19th Amendment, and some challenges, limited challenges, to protective legislation. Step 5 is the Warren Court saying, we got to get the federal government under equality to get rid of segregation. You see. Step 6 is the 1970s, where that same principle of equality goes after sex discrimination in various different ways. And our stage, step 7, which is not about minimum, drinking age laws and various regulations, but going back to sort of primordial institutions that are the foundation of societies, like marriage, or like militaries that can win wars and prevent your population from being killed or enslaved by foreign. All right. Thank you all very much. I'm very happy to take questions.
I'm really curious. Have you heard of a movement among women demanding the right to be drafted?
I do not know.
You know what it is, but I know they're going to be drafted.
Yeah. I can. There are lots of women there are lots of just Americans of both sexes who are who insist upon bringing into play. Oh, thank you. Who insist on bringing into sort of fruition a kind of the principles of a kind of gender equality that find all of the sort of things I'm talking about. I mean, the reasons why you would not draft young women are irrational, unjust, corrupt social constructs, paternalistic. There's lots of different kinds. So yes, I know a lot of men and women who would be, and in fact, on the Supreme Court, I suspect you have all of the women right now would vote to strike down the military draft, much as all of them voted to strike down male-female marriage in the Constitution. Yeah.
You brought something to my attention. Now, my dad was the prosecuting attorney, my uncle the federal judge, and my cousin was on the Court of Criminal Appeals for the state of Michigan.
Yeah.
And I remember back when you did in 54 you're talking about,
yeah,
when it said when it's school segregation. Okay, the big question that they had at the time was that, the Supreme Court says a ruling. Who enforces it? I mean, and they said that it's up to the president to enforce it. Until Eisenhower put troops in, they weren't segregated.
Yeah, that's right.
Okay, then why does Trump sit there and let these these judges in California, one judge sit there and say, you know, I'm taking care of everything? Why does he not just sit there and say, hey, I'm ignoring you because you can't enforce it?
There are two different ways of presidential sort of non-cooperation to think about. One is action in defiance of an order, and the other is inaction in defiance of an order. And politically speaking, it's easier. So that the case of Eisenhower. Let's suppose I think Eisenhower acted right at segregation was unconstitutional. But suppose the president that segregation was totally constitutional. This was just an outrageous usurpation. If President Eisenhower does nothing, he's not going to have to pay as much of a political cost. So what's going on with Trump in the immigration case, the president would be acting in a more, shall we say, unorthodox and maybe even unlawful way in getting a thou shalt not from a federal judge and saying, I'm just going to go ahead and do it too, as well. And not only that, but doing it in such a way that there are parties that are affected that are going to protest, and they'll be in front of another court. Because let's say you arrest somebody, well, they go before a judge, and then the judge the president's going to constantly be defying judicial decisions, defying them by action rather than inaction. And that's a very different political thing. People would not have gotten very angry at Andrew Jackson, for instance, after Worcester versus Georgia, where he's not going to raise an army to go invade Georgia. And he doesn't have the 101st Airborne Division. So yes, he famously said, well, Marshall's made his opinion, let him enforce it. But it's a different thing if the president is given a thou shalt not, and the president
That's one thing I say, you know, like I say as a kid when it happened. And I just always wondered, you know, why, you know, who's going to enforce it? You just answered my question.
Well, didn't they do the same thing with voting rights?
Now speak up, please, so we.
I said, did they not enforce it with federal people for the voting rights?
Yes, and that was a big, one of the amazing, terrible chapters of our history. The 15th Amendment says, neither the United States nor any state shall deny or abridge the right to vote on the basis of race, period. Everyone takes an oath to uphold it. And frankly, just in many parts of the South, they just said, by force and by fraud, we're going to have an all-white electorate. The 15th Amendment is a piece of paper. The only way you overcome that is with force. If you have, and the American people in the northern states did not have the political stomach for an extended, large martial occupation. They already had one of the American South. It wasn't until after World War II when a couple things happened, but one of them is resistance was not nearly as strong in the South. 1890s, not the 1950s. 1890s was crazy, the number of lynchings, just insane. And secondly, they passed the Voting Rights Act, which is finally passed and enforced, and you have a federal government that's willing to use substantial military force. Also has 101st Airborne Division at its disposal, which is what.
And the anti-effective was there too.
Yeah. Yeah.
All right.
President Trump's talked about looking at the 14th Amendment again, especially the subject to jurisdiction thereof.
Yeah.
To look at the anchor baby type. If
Yeah.
you're born here, and then I know there's a footnote, and so I was wondering if you could speak for 30 seconds or whatever, give me your opinion on whether there's a leg to stand on.
Subject to the jurisdiction, my own opinion is I understand why people are concerned about that problem. That's another indication where the Constitution says one thing, we have a problem. We have to amend the Constitution rather than saying it doesn't say what it says. It says everyone born, and it says and subject to the jurisdiction thereof. That was designed to exclude people who have diplomatic immunity and therefore can't be usually tried or arrested, members of Indian tribes that had a quasi-independent status, and members of invading armies. But the problem we're dealing with in terms of people illegally entering the country or entering a birth tourism, they are born here and they are subject to the jurisdiction. You can arrest them. They can't claim illegal alien immunity. They are 14th Amendment citizens. And the text of the 14th Amendment, as originally understood, was plain that it would apply to the children of aliens. This is often brought up. Well, not the children of aliens. Not only the text, but the debates. All the evidence that I've seen, and I've spent a lot of time with it, indicate that they understood that the persons born in the United States of the jurisdiction thereof include the children of aliens, and without any kind of particular exception for, unauthorized.
Most of them were back in that condition.
Yeah, most of them were legal because we didn't have many immigration laws. So most aliens were not illegal because there weren't laws prohibiting as much arrival in the United States.
They may not even been born here.
Well, we don't know, so you can guess.
Some of the are located.
Yes, please.
I
Yes,
was
please.
Alexander Hamilton with an office.
Yeah.
How about reviving the doctrine of nullification on some of these crazy things that the courts do and the Congress puts forth?
You know, it depends on what type of nullification. I mean, that's another, nullification comes in various different forms. There's the form of state non-cooperation, such as states refusing to participate in gun background checks. Our sheriff's one, that came up in the 1990s. There's another thing of states arresting federal officials for doing federal duties. That's a little bit more aggressive. Congress says go do something, or the Supreme Court says so, do something. That has actually happened, and the most famous nullification of that occurred with respect to the federal fugitive slave law, where the federal fugitive slave law, the federal Supreme Court upheld it 9-0.
I can't arrest the state regularly.
And the state of Wisconsin was arresting people who were out getting slaves, saying you're kidnappers. The case goes to the Supreme Court issues an order in Wisconsin. Wisconsin says you don't have jurisdiction, the law's unconstitutional, we won't obey you. And this is right before the Civil War, by the way. So it's a word of caution. Most aggressive forms of nullification signal the disintegration of the Union.
So how do we get around with the drug laws that are federal? We have a few states that don't recognize them. Because that's the reverse, right?
That's right. So the Congress says thou shalt not, or the federal government says thou shalt not. The states say, oh, go ahead. What do you do about that? Well, strictly speaking, it's simply a matter of whether the federal government has the political will and the resources to just keep enforcing the law. That really is. So that's not a question of nullification. It's a question of prioritization and a certain not unwillingness to commit resources to those things. There's lots of laws like this. You know, how did we get the internet with all its obscenity? We actually have federal anti-obscenity laws, but it just became very uncool to enforce them. So the Department of Justice just stopped doing it in the 80s. Because nobody wanted, all of the people that want to be prosecutors, they don't want to do, this is not cool. And it's nobody likes it. So it's very similar now. It's uncool to arrest marijuana dealers. And it's amazing how much custom and fashion dictated from a certain function of society can indeed change what prosecutors do. Because the best and the brightest who go to work in the DOJ want to arrest, you know, they want to go prosecute mafia pins or whatever. And they don't want to be arresting people who are producing dirty books or whatever. But it did produce, it was partly responsible for a massive transformation of our society. Such that now, I mean, the average 16-year-old boy has seen massive tons of pornography. Where I'm just being blunt, I probably saw 2 naked lady pictures when I was 16, by the time I was 16. And then you had to like find those things.
Notice he remembers it.
David, thank you.
That's right.
All right. Now, let's take a minute here. I notice our mayor is here, but let's take care of a couple of items of business. And then, George, we got to get Delar, you got your PowerPoint and everything. Delar, if you help him get set up, you and Jim. Let's have a little business here. Let's take care of it. We have a young leader, Chuck Branch. Chuck, come up. If everyone doesn't know Chuck, he's now an SREC leader, okay? And Lincoln Day. All right. So give us a little report and bring us up to par as they get ready technical.
Okay. I won't give you an SREC report this evening. We had Chairman Dickey here a few weeks ago.
Who's noise? Somebody's got to fine $2. Okay.
Right. He was here a couple of weeks ago and discussing some of the challenges we're facing in the 2020 elections. And I'm going to put together a slide as a presentation, and Richard's invited me back to come give that presentation to you. He said I could take the whole time as long as I wanted. But no, just kidding. Everybody knows better than that. But it's regarding Lincoln Day dinner. As everyone knows, it's March 30th at the Delta Hotel in Allen. Has everybody gotten their tickets? Yep. Is there anybody who doesn't have their tickets yet? Please go on. All right, we got about another week left for you to get your tickets. So we have in attendance, the speaker is going to be Representative Dan Crenshaw, Lieutenant Commander, Navy SEAL Team 3, and special guest Katrina Pearson. She's a senior advisor to the Trump campaign. As a matter of fact, yesterday I got the signed Trump hats. So I got 5 of those. You saw those, so those are going to be going up for $1,000 a piece. And I think Richard agreed to buy 2 of those. But we're needing some more veteran donations. And if y'all could, you could sign up, get tickets for the veterans. We're going to have special presentation for them as well. Judge Roach has donated, not technically donated, but he's given us all the flags for the different services of the branch. We are needing the flag stands. So if anyone can help us get those, or anyone who can help us get a couple of those or get all 5 of those. No, we got 2. Those are 2. But we need 5 more. If someone could look around and help us get those, we greatly appreciate it. So if you have any questions, Chuck Branch, and certainly be happy to help you.
Okay.
All right.
Thank you, Chuck.
Thanks, sir.
Thank you very much. CCRMC, we now have 5 tables. Okay.
5 tables.
And
Wow,
we're working on a 6th.
Are you?
All right.
Okay.
And for everyone's information, as a permission from our trustees, we're going to be the sponsor of a special table. There's a special presentation for our historical leaders.
Yes.
Florence Shapiro, David McCall, Jody Lottenberg, and Jerry Madden.
Looking right at it.
I want to know if he's going to say anything. He's forgotten. But their history.
Brian gonna be there?
Who?
Brian?
Brian's going to be there. Brian's there. Very good. This afternoon, Jody's not going to be able to be there, but she's requested a couple of our distinguished citizens to stand in for her. And so we're very pleased about that, and that's going to be Jane and Jerry Yancey. Okay? But the CCRMC, your club, thanks to the donation of many of those members, we're sponsoring their table. So that was $1,200 that everybody came up and contributed. So it's a good publicity move, political move for our club. Okay? But it's even a more historic event that the committee approved to recognize the historical leaders of our county, the people that put Collin County on the map. Chuck, thank you very much. All right. Now, Neil, I'm going to ask you to say a few words in a minute. But now, we have I'd like to show, I don't know if we can show it, but you've seen it before and we can go back. But every one of you know how to get in touch with your state legislature, right? You go to the state website, help me out, Jim. What's it called? State of Texas? Our legislator? You put in Jeff Leland into Google. You put any of our representative, Matt Shaheen, it goes to the home site of the state legislature. You can follow every action, every bill they're sponsoring, co-sponsoring, and you can educate yourself and be informed in what's dealing with them. Right now, we have House Bill 2 that creates a tremendous amount of concern. And we have a tremendous honor to have our mayor of McKinney that's going to come in and tell us the effect that House Bill 2 is going to have on our community. Sir, are you ready?
I'm ready.
Okay, come on up. Now, we want to turn off this row, I believe. Turn off that front row.
I look better if you turn off all the lights.
The lights, the party's over.
So on the presentation, I've got a few slides that are McKinney focused, but just to give perspective, McKinney's going to be representative of many of the cities, certainly in Collin County. So if you're not from McKinney, the data is still going to be relative to the discussion we're going to have. Go to the first slide. So Texas cities, right? We know that we're the best state. We know that we're the best county. We rank among the top cities in the nation for job creation, population growth, and best management. In Collin County, we have 2 of the fastest top 3 growing cities in the country. That's our beautiful historic downtown, by the way. Yeah. Next slide.
Trying to get there, live, work, and do business. Here we go.
Texas lead the nation because they provide the services and infrastructure that businesses need and the quality of life people want. And I'll get to the meat of this presentation if you like. If you're from McKinney, you already know the things that are not shown on the screen right now for some reason. We're voted #1 best place to live, and there it goes. #8 for first-time home buyers, but I guess we're lagging. You can skip to the next slide. There it is. Best place to live by Money Magazine in 2014. If you didn't know that. Next slide. You can go to the next slide. McKinney-centric again. So, property taxing entities in the state. I'm sure everyone here knows that. Cities collect 16% of property taxes within the state. School districts collect 54%. Special districts, college districts, for example, utility districts would fall into that, are 13%, counties 17%. Next slide.
Doesn't always want to take, I don't know what's going on.
What's that?
Doesn't always want to
Yeah.
slide over.
So again, this is McKinney, but it's going to be very representative of other cities in Collin County. Median price home may vary, so this dollar amount may vary, but the average total tax levy in the city of McKinney is broken up as you see it. ISD is $5,442 an average home tax levy. City of McKinney $1,797, Collin County is $619, and in Collin College $278.
Mayor, how are you dividing that between homeowners and businesses?
This is not broken out, but roughly 80% right now is residential, 20% is business. Something we're working diligently to change and bring business and commercial tax base up.
That number is just for the homeowners?
No, so that's property tax levy in general.
In general,
Yes.
for both homes and business?
Yeah, it's based on the average property tax levy for the home, but it's
Thank you.
proportionate for the businesses as well. Let me make sure I was clear on that. That was for a particular homeowner, but those percentages are accurate whether it's a business or a home. But to the average $348,000 home. Okay. What do you get per month? Where does your money go every month out of the average levy? $10 goes to Parks and Recreation, $4 to libraries, $69 goes to public safety, Public Works $12. In McKinney, our public safety represents about 47% of our budget. There are cities in this state that represents 80% of the budget. Texas property taxes are higher in great part because legislation has been cutting state share funding for education. As you know, and you saw on the slide before, school taxes represent the largest portion of your property taxes. School taxes in 2011 education funded by the state in 2011. The state funded 48%, property owners 52%. Today that share is 38% from the state, 62% by property owners. Of course, the state decreases, we make up the difference locally. This slide talks about in 2017, the state adopted a budget that showed an expectation of school taxes at the local level increasing 14% over the next 2 years. This is just that bill, you can see this slide.
It's not all trees.
I wasn't all there, I wasn't there.
Okay, the next slide.
There we go.
A lot of people heard about recapture, some people call it Robin Hood. Every year, City of McKinney pays into recapture. Recapture, the idea behind it is that Collin County is a wealthy county. There are counties in the state and school districts that don't have the same opportunity, don't have the same tax revenue, don't have the same ability to provide the same education. The idea is that wealthier counties and districts will pay into the state and recapture. The state ideally distributes that to poorer districts so that every student in the state of Texas has an equal opportunity in education. This year we sent over $5 million from McKinney. Next year, under the current formula, we'll send about $11 million. The year following that will be nearly $20 million. Sadly, a significant portion of these funds go into the state general fund and not to education. So right now, we're going to get to HB2, SB2. I'm going to talk about HB2, which is the bill that has the most activity right now. There's a current movement, you know, in the state, and it used to be, you know, conservative values talked about local control. That's over the last 5, 6, 8 years, that's become almost a negative thing in Austin. Local control is almost a bad thing. That the state is introducing legislation every 2 years that is attempting to take control from local government, put it at the state level. HB2 is arguably one of those bills. I didn't know it was going to go away once it popped up. So did you read that fast? So among other things, HB2.
Sorry.
HB2 was introduced as a property tax reform and relief bill. We are told that in the substitute bill that's will be introduced shortly, that we'll see that introduced as a property tax reform and won't contain the word relief, which would be much more accurate. But some of the things that it does, it's great. It enhances transparency and truth in taxation measures. So much more information available to property owners to see how a city has arrived at everything from effective tax rate, how every dollar is spent. There's a lot of great measures. It reforms the appraisal value appeal and protest process. Right now, if you've ever gone through that, it's a difficult process. If you're not represented by a larger group or a firm, it's hard to get the same attention as an individual property owner. There's measures that change that pretty dramatically and give everyone an equal opportunity to protest their appraised values if they so choose. It provides for an automatic rollback election when triggered. Currently, it's only by petition. That's a positive thing. Voters should be able to have a say in a rollback rate that's greater than what's deemed fiscally responsible spending. It decreases the rollback rate from 8 to 2.5%. That's obviously a big part of HB2. Some of the concerns, you have to wait for them. So there's been a lot of talk. Why are mayors like me down in Austin testifying on a bill versus support of the bill? Because on the surface, let's lower the tax rate from 8% to 2.5%, the rollback rate. It sounds great. I'm a taxpayer before, during, and after being mayor. I want my taxes as low as they possibly can be, but I want to live in a city that provides the services that I think are commensurate with what my expectation is. So why am I down talking about it? We missed the first one, but current cost drivers are not taken into consideration. Currently in North Texas, inflation, just CPI, inflation on grocery goods, socks, eggs, milk, has been tracking between 1.9 and 2.4%. That's not really what makes up a budget for a city. What makes up the largest part of the city's budget are wages, sworn wages, or fire and police, and these are contracts that are longer-term negotiated contracts. Healthcare for those contracts, those things have been tracking between 4 and 5.5%. Healthcare up as high as 6% annually. Construction cost inflation index has been between 4 and 6%. If you're in the construction business or you've tried to build something or buy a new home, you see the prices going up, and that's the reason. So cost drivers are not taken into consideration that are commensurate with the economy we live in. Right now, property tax relief exemptions are the biggest way a city can give property relief. In McKinney, we have an over 65 and disabled exemption. That exemption right now saves an average homeowner $348 a year. Okay? If, under the current way HB2 is written, a exemption counts against the rollback rate. So the first thing cities will do, if they determine that wages, healthcare, road construction is much higher than 2.5%, the first thing they'll do is, as opposed to chance going to an election, especially the way the laws are written now, how you can go to election, or what will be on the ballot, what you can say on the ballot, what you can or can't advocate, we'll get to that in a minute. The first thing you do is the city will take away an exemption. They'll rescind an exemption. In the city of McKinney, the last 2 years, for example, we've been at 2.9% on average over the rollback rate. Had it been 2.5%. First year I was mayor, it was 1.9. Last year was 2.9. If we had been under this rollback rate, and we determined that we did not want to go, or we wanted to go to an election, we would have been going to the voter for an increase total of 44 cents a month. The real portion, though, that is affected here would have been just the M&O, and I guess I can talk about that in a minute. But the bottom line is it would have represented a 32-cent a month savings to you. Now, if the city decided that, hey, we can't take a chance of going to the voters. One, right now, the way law is written, we have to write on the ballot that we want to increase the tax rate from X to Z, and I can't explain it. I can't tell you what it's for and what the difference will be to you as a taxpayer. So if we were to eliminate an exemption, what a horrible thing to eliminate an exemption that's saving someone $348 a year to save 32 cents a month on the M&O portion of it. It doesn't take into consideration revenue sources. Property taxes is just a portion. There are cities, ours represents 32, 33%. There are cities like Sugar Land, 50% of their revenue for their budget is sales tax. Now in Sugar Land, in the last several years and what they project moving forward, is a flat growth in sales tax. So to a city like Sugar Land, if you have a 2.5% cap and half of your budget is property tax, and that's a 2.5, and half of it grows at 0, you have an effective growth rate of 1.25. I don't care what you look at, any index of any kind in Texas, inflation is more than 1.25%. Conversely, in McKinney, although our percentage is lower, sales tax is growing at a much greater rate. So we might, if you average out the 32% of sales tax revenue, and that's growing at 5.5 or 6%, we may then end up with about a 3.2, 3.3%. So that's an inequitable situation between a city that will have an effective rate of 1.25 and a city like McKinney at 3.2, 3.3. If we were to determine that 2.5 was the correct amount, and we need to take into consideration what are the revenue sources. Because at the end of the day, all of that impacts the budget. I think we're missing the next. How'd you do that? Very nice. The other thing that's been discussed, and it's a very real thing. We have a AAA credit rating in the city of McKinney by both Moody and Standard & Poor's. That's a big deal when we issue bonds. We have a bond election coming up, $350 million. Infrastructure, roads, fire stations, a number of things, parks. We enjoy the lowest possible rate on those bonds. One of the criteria, or one of the things, measures looked at by a rating agency is what is a city's ability to raise revenue. What if 2008 happens tomorrow? Well, when your revenue cap or rollback rate is at 8%, they know that at any given time, any given budget cycle, the city can raise the taxes to 8%. If that's all of a sudden 2.5%, that impacts our ability to raise revenue. It has an effect potentially on our credit rating. I'm not suggesting that's the only reason to discuss whether 2.5 makes sense or not, but it's another condition that we are urging legislators to look at, whether it's a state stopgap or some way that protects a city that has been a fiscally responsible city, enjoys a fantastic credit rating. We don't want to penalize taxpayers now with higher bond ratings or bond rates, debt rates, because of a change in our rollback rate. And the last one, I believe, current ballot language is insufficient for rollback election. I alluded to that before. We are pushing legislators that whatever the rollback rate is, if we're going to go to have an election for taxpayers to decide whether or not we are above that rollback rate, they need to be informed. If I'm just a taxpayer, I'm not on council, I'm not in the budget cycle, and I go to election day to the ballot, and it tells me current rollback rate is 2.5%. City of McKinney is asking for putting a proposition forward to vote yes or no to raise it to 3.1. Well, in a vacuum, do I want to raise my taxes from 2.5 to 3.1 over the effective rate? My answer is no. Now, tell me that what it will mean to the average homeowner is an increase of roughly 44 cents a month, and we will be able to build a fire station that's needed in North McKinney. That's a different answer, potentially, for me. Having information, being informed is very, very important. Currently, that's not available. So whatever the rollback rate ends up being, whatever the change is, let's also fix the language in the law. Something I don't have on here, but equally important, is as a mayor, as a council person, if we're going to come to the voters and ask for a rollback election that's greater than the rollback rate, I need to be able to advocate. If you call me in my office and you say, hey, George, you know, I understand on the ballot there's a proposition to increase the rollback rate, our taxes would increase X amount. Do we really need that? Now, currently, if I answer that question, I advocate and I tell you that we need it, I'm committing a Class A misdemeanor. It's a crazy thing, but literally, I could be fined $1,000 and go to jail for up to 6 months. I need to be able to advocate if, in fact, I believe that it is important. If I'm elected, I was elected because people felt that I was, they wanted to put their trust in me, and if I believe there's a need in the city, I need to be able to speak about it. Next slide. Discussion, is it?
Who pays for the election?
The city pays for the election as well. Yeah.
Is
So
there
wait a minute,
election?
Jane, what's your point?
Well, who pays for the election? The state's making you call it,
Yes.
and the city has to pay for it. And then if it doesn't pass, you're out the cost of an election that is a waste of money.
Yeah, and there's actually so many other aspects of it, and I try not to get bogged down in the detail.
But you're asking a question about a rollback election.
Right.
Right.
If it's triggered, why did the state pay for it?
Now, to be fair, one of the things that at that point was brought up, so one of the revisions initially was to make sure that we try to time that rollback or that election with another election. But you still have to, someone's got to spend money, someone's got to educate the public, money will be spent, the city, I'm sorry, go ahead.
I have problems with these, not our counties, but some of these smaller counties that have expenses and no revenue. If they're held to 2.5%, they may go out of business.
Well, so, again, yeah, true, yeah, I believe that, number one, 2.5 wasn't pulled out of the air. Let's all agree that hopefully our legislators didn't throw a dart and just pick 2.5.
2.5 minutes for a long number of years.
Yeah, it's the last several years ago, it came out 4, 4.5, 5, 6, it's been a lot of different numbers. Yeah, but it's been talked about a lot. So let's assume that, hopefully, right, that there was thought put into that. And if I believe that thought was put into it, what would the criteria have been? Well, the criteria would be, what should a city be able to operate fiscally responsibly on without any fact? Just operate, you know, within the, to provide the services that are needed in that city. Well, if I believe that's the number, the very first thing I've got to say is, well, hold on. If I believe that 2.5 is the growth of that budget that's commensurate with what is needed based on inflation and other drivers, and I know that there's a city that half of the revenue is sales tax and flat, then that mathematically, it's not opinion, it's factually, that I've just saddled that city with 1.25. So if I'm going to have an election every year, I want to make sure that's $2, sir. If we're going to have an election, let's make sure that that election is if it doesn't pass, it doesn't mortally hurt that city. Yes,
Go ahead. Wait, did you finish your point?
Yes.
All right. You had a question, Jim.
The advocates of this down in Austin are suggesting that the elections would always be held in November, not
Correct.
May. And I've got a two-part question.
Just changed it, yes.
Okay, because if there's not an election in an odd year, which often is the case, what would the cost to a city like McKinney be for that election?
And as I said, to be fair, that they did change that in a subsequent version. That in the right year, it would not be an issue.
So do you pay for, if you have something on the November ballot, or you're not having an election in May, but the other cities are, what's the cost of the election?
About $750,000.
So it's a material cost.
And I didn't get bogged down in another detail, but keep in mind also the way the budget cycle, one of the other things that we're pushing for, this isn't just about what the rollback rate is, it's all the other things that weren't considered. What are the revenue sources? What is the ability to advocate? What is the language on the ballot so that we have to do that? What timing of the election? Right now, where the budget cycle is for the state of Texas and cities, we virtually have to, or literally have to create two budgets. One if it passes and one if it doesn't pass. You have time and effort and expense in two budgets. Then you have to start operating on one of those budgets, not knowing which budget's gonna pass. So timing issues, we're pushing for that. There's just, it's, when I went down to speak on the bill, the soundbite is, oh my God, mayor is fighting to keep your taxes high. Well, that's a cheap shot, and it's absolutely inaccurate. What I'm fighting for is, in 116 pages, you've missed many things. Now, in the Senate, there was absolutely no desire to have that dialogue. In the House, I was asked in to speak with the chairman. I spoke with 4 of the members of the committee, and every one of them wanted to understand, what are your concerns? And we talked about them. And I will tell you that when we first started talking about revenue sources, that was not something that was considered. We literally had to go through an education process of revenue sources and what cities have, what percentage of their budget and how the effective rate, if you're 2.5 and that's only half your budget is property tax and half is sales tax, then your effective rate is whatever the average between the two. That had not been thought about. And a myriad of other things. So when we're down discussing this bill, it's not all about 2.5. It's about what is the right rate that takes into consideration the actual real cost drivers today. How do we make sure that election, if there's an election, is not costing the city $750,000? How can we time it to where we're not doing 2 budgets and having to pick which one we're going to gamble and operate on this or not? How are we going to make sure that we don't penalize? I mean, can you imagine cities that all of a sudden were withdrawing and retracting home exemptions? And by the way, I gave an example of last year, 2.9. If the difference between 2.5% and 8% in the city of McKinney to the average household is $6.40 for the entire amount, and actually, again, I don't want to dig into the weeds too deep, but this bill only covers what's called the M&O, maintenance and operations portion, which is roughly 60-ish%. So really, we're talking about a $4.20, $4.30 difference to the average homeowner in the city of McKinney per month. Now, I'm not saying that's not money. It's money. It adds up. But if an exemption is taken away, that's saving you $28, and the most that it could cost you is the M&O portion, $4.40. That's not a good trade. So if nothing else on the bill gets fixed, let's don't penalize cities, homeowners, by having that exemption count against the rollback rate formula. That would be devastating. Our greatest way to provide tax relief in the city is with exemptions, plain and simple. We're also talking about increasing exemption amounts that are available to a city to offer. Not just percentage, but even amounts. So a person that owns a $250,000 home has the same exemption ability as someone that owns a $400,000, has the same savings ability. There are so many aspects of this bill that people want to boil it, some people want to boil it down to a soundbite of it's trying to keep you from having to vote or increase your taxes. And it is so much more than that. There's so much more at stake that people do not realize because it doesn't fit on a bumper sticker. For me to explain everything I did, and I'm leaving out 95% of the other stuff just to try to have this conversation in 20 minutes, it is so much more than a tax rate. It's so much more than $4.40 a month or not.
So what do we need to do? We need to call our representative?
You need to call a representative. You need to take the time to research what I'm saying. When you do, you'll see what I'm saying is accurate. You need to, I like to research when I hear somebody talk about these things. And then you need to contact your representatives because again, there was just a mailer I received in the mail that basically put what I said to a soundbite. And I was listed in Texas scorecard as your worst enemy is your mayor. He's fighting against your taxes. The Texas Tribune wrote an article that said I'm your worst enemy because I'm trying to make sure your taxes are not lowered. Legislators need to know that people actually understand there are many aspects. And again, it's not just the rate. It's the rate, it's the election cycle, it's the exemptions.
It's the local
It's
control.
well, and I left out, the city gave me a presentation to bring that was 37 slides, and it was all centered around local control. I decided not to go through all that. Do I believe that local control is important? I do. I don't believe that the Austin legislators understand the city of McKinney. I know that when they put forth a legislative bill that has one city effectively capped at 1.25 and another one, there's one city that has 60% sales tax revenue going at 6%. They're at 5.1, I think, was the average. That's not equitable. But that condition varies, city to city, state, region to region, county to county. So what you need to do is contact legislators and tell them that you understand there's more to this bill than the soundbite of 8 to 2.5. And that, well, again, I would ask you to do the research and then talk to the people you've elected and tell your legislators that you want to keep that decision here at your level.
Being a native Texan, I think their local guys can handle it a lot better than Austin.
Yeah.
Okay, so I have a little,
Well,
I can say that.
20% of your recapture that we sent to the school district taxes went back to education, 20%. So in 2 years, we will send out of the city of McKinney, $20 million. Do you know what that will do to property taxes for school? $20 million. I didn't get into unfunded state mandates. We have this past year, we paid over $2 million to the state. We did receive $12,500 from the state. That's what we received, yeah, last year. Literally, that's the only money we received.
So everybody knows, you're a developer, you
Yes, I
deal
am.
with cost, okay? You know profit and loss.
Yes,
I
I
mean,
do.
it's not an academic situation or philosophical one. You deal it from a pragmatic daily operations,
I do.
okay? And so I think that adds value to his interpretation and your concerns here.
And I'll say one last thing, and I do not mean this in any, I am a builder and developer, and I'm very confined in one neighborhood, 46 acres in the city of McKinney. Never taken a penny from the city, by the way. But with the properties that I'm involved in, I have ownership in, and I'm part of the partnership group. This past year, we wrote a check for over $1.2 million in property taxes. So if you don't think that property taxes and lowering property taxes is important to me, as I said, before I was a mayor, while I'm a mayor, and long after I'm a mayor, what I fight for today affects me just like it affects you. And in my business, it affects me in a huge way. What taxes have done to me and some of my properties has turned me from a profitable property to a property that's not profitable. So I want property tax relief, but I know that right now there's again, great soundbite. Hey guys, we're gonna give you property tax relief. We're gonna lower the rate from 8 to 2.5, and then everyone gets focused on that shiny ball, but we forget about recapture. We forget about defunding of schools on the state level, and none of those conversations rise to the top because they just looked out for us taxpayers. So it's a fight.
I as a former state rep, that's not fair, Mayor. That statement was not fair.
Well, tell me what's not fair.
The legislators, we think about all of our citizens, both corporate and individuals, and take all of their thoughts into thought. So some of the people that are on one side are not on the same side you are, but they have a right to have their voice said.
No, they absolutely do, sir, but when you have, and you're right, by the way, I should clarify and say, when I speak of legislators, I'm not talking about all legislators, but I'm talking about right now, here's some factual statements. We've defunded schools at the state level from 48 to 38%. We have enacted recapture. We spend 20% at the state level, goes back to education, the rest goes to the state fund. We've been growing the state budget over 6% a year. The cost in the city of McKinney, for example, cost per capita resident over the last 10 years has grown, on the whole 10 years, 4.2%. At the state level, it's 18.7%. And that's after all the unfunded state mandates. So although I believe you are correct, and I have friends at the state level, everyone wants to do good. No, I don't believe that there's any cynicism that people are getting elected and wanting to hurt taxpayers or residents. I get that. But the fact is, we have a state budget that is growing at a pace that the cities have been subsidizing now for a long time, from unfunded mandates to education, and that's a fact. That's not my opinion. That's
I'm
dollars and
not so
cents.
sure about the city stuff.
Okay, go ahead, the last question.
Well, but unfunded mandate, sir, if the state is
Well,
requiring
we all
us.
agree about mandates. Let's talk about, no, I'm not gonna get an argument.
Oh, no, but I
I'm
mean-
not gonna debate anybody. Okay, I'll talk
I
later.
just want to mediate this.
Sure.
The strong accusation stands when it's launched at particular special interest groups.
Absolutely.
Yeah.
I think that should be.
Absolutely, absolutely.
And I won't say Empower Texans in particular.
No, I would never say that, but yes. No, absolutely. Listen, Empower Texans
Come
have
out
written,
fighting.
I have had
Too old.
nasty article after nasty article written, because again, the soundbite.
Right, they're the bumper stickers. So that strong accusation stands against some
Absolutely.
groups.
And well
And by the
said.
way,
Yeah.
those people are on both sides of the issue.
Some are.
Okay.
Yeah, there.
Any closing, last questions? David, okay, yes, sir, Professor?
Just, I'm sorry I'm not a member here, but I would like to just
You can be.
raise a question.
Richard may take your donation right now.
Let me, I mean, I meant to maybe as a suggestion. Obviously, what's behind all of this is the notion that despite the sort of nominal democratic character of local government, that it's not, that it doesn't work. The reason you can't sell a tax increase is because you're not connected with people despite the nominal democracy. That would be the claim. And I agree with you, this looks like a ham-fisted, just kind of block-headed, well, we'll make them have elections every year for their budget. But I'm wondering if there is, I mean, I don't have a particular solution, but you all in local governments can't think of a way to come up with some alternative proposals that have nothing to do with this particular 2.5% Just something to acknowledge that taxpayers often do feel, despite their nominal vote, that there is just like somebody else is making all these decisions, and then we get a big fat wad, a big massive bill at the end of the year. If there's some other way to try to address at least the perception of a disconnect, that you're elected, but you're really not.
It should be
You've
pointed
got
out.
somebody else doing, you're working some other
And
way.
it should be pointed out that a lot of people go to the appraisal districts and think their appraisals have been rather unfairly done.
Yeah, well, no doubt. And listen, there's a lot of people in my position that are making the statement, hey, it's not the city, it's the appraisal district. But here's the reality.
But
Whether
the reality is, you
it's-
point people on the appraisal district.
Well, but even, forget that, let's say we appointed everyone, and let's say we're responsible for the appraisal district going crazy. At the end of the day, the city has the second part of that equation. So I don't care if the appraisal district came and raised all of our property values tenfold, we could have a rate that reflected that. Now, I just gave two absurd examples, I don't think I can make up even with 0%.
No, I agree.
But my point
You're
is,
right there.
there's no, that's not it. Don't let elected officials off the hook by them saying it's the appraisal district. We have half of the equation.
I
I
don't-
have something.
You can lower the
I don't
defendant.
know.
Okay.
I'm sorry, but as citizens, I have never missed but one vote, and I'm 78 years old. I go and vote, I work for good candidates, invest a lot of my time, hoping we're going to make a difference. In reality, lobbyists are behind all of this. Am I wrong?
I'm not saying anything.
And we
We could, that's, I love to get that discussion about campaign finance reform and all, and put an end to so many things, but.
I'm sorry, I've opened a can of
No, I
worms.
couldn't agree more.
Now, tomorrow, we can't remember all this. Is there a website or someone, if they need to refresh what you're saying?
You know, it's the same thing that was suggested before about just Googling, if you don't know how to get in touch with them, you can Google your representative, both House
What
and
is the
Senate,
bill number?
HB2. Just call Jersey.
George,
Yes,
one,
sir.
one thing, my observation is we're talking about taxes. What you need to have is a transparency of budget.
Yeah,
Because
absolutely.
you spend your budget right, and then you have to collect the money. And, I mean, if you want, if Empower Texas wants you to have a lower budget, I mean, do they want to pick a fire station, a police squad? I mean, what do they want to eliminate? Because you're giving up something to reduce the budget. I mean, that's the whole answer, and I think
Absolutely.
there needs to be better communication of this is what our budget is, this is where our revenue comes from.
For the city of McKinney, you know, we were the first entity in the entire state to receive the 5-star Transparency Award. So one thing we've done before any other city, and many cities are still not doing it, But our budget, worksheets, everything is online and has been for a couple of years. But you're right, the majority of the cities, it's a lot of work to get to it and to get detail beyond just a line item is very difficult.
And you need to disclose on your sales tax collections how the state keeps 1% of it.
Yeah.
Because nobody understands that. The state funds their whole controller department from the 1% they take out of the 1%.
By the way, that fee was doubled.
Oh, it's 2%. Yeah, they're short, so.
All right.
But they're helping us.
Thank you, everybody.
All right, now, let's cut this off, and everybody get their ticket ready.
That was great.
There, thank you.
What he said is really very
We don't have a collector, okay? All right, everybody get their tickets ready, but right now, it's all our candidates, let's have our candidates and elected officials come over on this side, so we can have a parade of candidates. So everybody, you've been practicing your 1-minute speech, okay? So get ready. All right, who else? Where's Jay? And Judge, come on, elected officials first. Let's see Judge Yarber.
Yeah, I'm Mike Yarborough, Justice of the Peace. I say the first.
That didn't count.
Get a roll.
That didn't count at all.
Just trying to speed it up, Richard.
Okay, come on, you first then. Come on. All right.
I'm Mike Yarborough. I sit as Justice of the Peace in Frisco. See, I've been doing it for 20+ years. I think Phyllis brought it to my attention the other day. You been there that long? Great program tonight.
Thank you. Young man?
Tim Chappell, I'm running for Board of Trustees, Collin College. I'm a practicing doctor. I was the one and only care medical supervisor at the college for 28 years. You have one of the top 5 programs in the country. So I have a unique perspective on healthcare and healthcare education that I think will be valuable to the college, since that's a major part of the growth. I'm not about healthcare. The college, I think, is a dynamic, well-run institution. Let's keep tax rates low, fiscally prudent management. Let's keep it available to all students with low tuition, and let's keep collaborating and talking with the workplace to keep our workforce educated, growing, because the prosperity of our county in the future is a highly educated, available workforce, and we need to keep after that.
Thank you. You need any money?
I've got a candidate, an opponent, so I am in a competitive race. So
And you have a website?
I need all the help I can get. electtimchapel.com.
And then go make a donation?
Yes.
Okay.
I'm not appreciated.
All right.
Thank you.
Thank you, sir.
Sure.
Young man?
Jay Sad, running for Collin College, Board of Trustees as well, position 2, running unopposed. So if I can get my wife, I can talk her into it, I'm in. The main reason I ran for it, I've got 3 kids in college. All 3 of them at the same time in college. I understand the value of an education. I've also had my kids have the opportunity to go to Collin College with the dual credits. So while they were in high school, they were able to get some additional credit. So take advantage of that. We need to make more people aware of it. Back to Tim's point, we need an educated workforce. I'm a pro-business, and the only way we're going to continue to grow businesses into McKinney, into Frisco, is to have an educated workforce. And right now, by the year, I think it's the next 10 years, we're going to need 60% of our kids that are graduating from schools are going to need a higher level education, a 2nd degree education. Doesn't mean you have to have a 4-year degree, but they have to have a 2nd degree education. And guess what? We're graduating about 40%. So there's a big curve that needs to be closed. And our college can help with that. So again, Jay Sad, Collin College Board of Trustees. Thank you.
Thank you, sir.
We will take donations too, Jack?
Yeah.
For Richard?
I'm Gary Edwards. I'm your constable on the east side. I've been a constable, or a deputy constable and constable for the last 44 years. So I appreciate you voting 2020.
Let's have a couple of, who wants, hey, my bride's here tonight, and she's up to 80% come on up, love. You can be our mannequin. You need some help? Okay. Come on up. Who's got the bucket of tickets? All right. Now what we do first, love, is we spin, see what the prize is going to be.
Big money, big money.
10,000.
Oh, yeah,
All right, what's the number?
10.
10.
10,
Mystery guest.
okay, what does it say there?
Mystery
Mystery gift, okay? Now, what do we have? What do you do with the mystery gift?
It was in Dale's office.
That's why it's a mystery. I'll tell you what we're gonna do. We're gonna make it a $50 gift certificate. That's number 9, okay? Just give a number, Lynn. What's the magic number?
The last 4 digits are 4245.
Oh, big by
All
one.
right, who's got it? Let's do it over.
A little collusion there? A lot of collusion.
So if you don't know, Lynn had knee replacement surgery, and the first Dr. Chapel, her doctor has a famous saying, deferred gratification. That experience is deferred gratification. All right, let's close it, close it. Neil, our executive director, our very talented young man that keeps everything glued together. Got a couple of comments?
Couple of comments. Main thing, of course, is Lincoln Days in 8 days. You know, Lincoln Days is our primary fundraiser for the party. What a lot of people might not realize, we do not get money from the Republican National Committee, so when you hear they raise $800 million, we don't get that. When you hear the state party raises money, we don't get that. What we raise here stays here. It's very important to keep the party open. We got a lot of work to do. We're already starting to meet and plan Victory 2020. So the doors keep open, my salary gets paid, which means Illinois State gets paid, actually, is how it works for my daughter. But bottom line is to keep the engine going in Collin County. We need your help. Please support us to be at Lincoln Day. Thank you.
Wait a minute, how many tickets have we sold?
We've sold about 650 tickets right now. Ticket sales will close Wednesday at 5 p.m.
Okay. Now, I want to recognize one other outstanding young leader that's becoming very involved in our club, Brett Wash. Stand up, all right. He's helping us also. Okay. Was chairman of the parade last year, and I think he will do it this year. Okay. So. Is there anything under good of the order? Anybody know that everybody's sick? Whatever. All right. Well, I want to thank everyone in attendance. I want to thank the Laura especially on our technical side. I think we had a couple of outstanding speakers this evening. Professor, appreciate your time and your message. All right.
Next month, sir?
Pardon? No, we're not. We're out of time. So we'll get it out on the email. All right, guys. All right, go ahead and tell them.
No, mystery guest, it's good.
Now, thank y'all for your attendance. Thank you for participation, and we'll see you next month. Okay.